Hello, my name's Camyron Holt, president of Instant FC, and I have about 7 years' experience in Texas real estate. And today I want to talk to you about Texas Administrative Code Rule 3.76, known in the industry as Rule 76. Now, this is not legal advice, but I do want to share my experience in preparing Rule 76 applications. I've coordinated the preparation of 4 Rule 76 applications that were all successful. And I just want to share my experience in the process of preparing this application because it's a very powerful tool to protect your property against oil and gas mineral owners. In Texas, the oil and gas mineral owner has a lot of rights, and they have a lot of rights to access the surface of your property. In a very inconvenient way. So this Rule 76 procedure establishes certain places where they can drill, certain places that they can access your property, and allows you to enjoy the rest of your property, not worrying about whether they're going to access the surface. So to get more specific here, a Rule 76 order can cover up to 640 acres. And what you can do within this 640-acre tract is you can designate drill sites, and the requirement is 2 acres of drill sites for every 80-acre increment. So if you have 79 acres, you need to designate a minimum of 2 acres of drill sites. If you have 81 acres, then you'll need to designate a minimum of 4 acres of drill sites. Now, part of the little tricky aspect of this is that a minimum feasible size of a drill site is 2.2 acres. So the absolute minimum is 2 acres, but you'll need to make a 2.2 acre drill site if it's just one singular drill site. So what I've done here is I've included a link to the PowerPoint that I'm showing you right now, and also within this PowerPoint there's a link to the actual Texas Administrative Code Rule 3.76 that you can look at yourself. Now, it's pretty bare bones. There's not a lot of information on the process. That's why I'm making this video. So I want everybody to understand this process and save a little bit of time with your consultants. You know, these are the consultants that you're going to use for this process can be very expensive. Oil and gas lawyers, $600 an hour. Oil and gas consultants, $450 an hour in some cases. Landmen, $100 an hour. So I just want to describe the property so that it's not the property, but the process, so that everybody understands it, so that maybe they can save a little bit of money in this process. So let's go to what exactly is the process, right? What I've done is I've outlined 13 steps here. That is the process for submitting a Rule 76 application and kind of completing the Rule 76 process. In future videos, I'm going to get much more specific about this process and provide some example materials to help you understand what exactly you need to prepare for these Rule 76 applications. So let's get into it. So step 1, you're going to need to hire a landman, a civil engineer, an architect, an oil and gas consultant, and an oil and gas lawyer. Now, it's very important that your oil and gas consultant and oil and gas lawyer have experience in preparing Rule 76 applications, and usually they have some statistics like we're 100% successful in our Rule 76 applications. And it's very important to have that experience because the judges who approve these Rule 76 applications will see these same consultants and lawyers and have a little bit more trust in them. Also, the consultants and lawyers know what it takes to get a successful Rule 76 order approved. So step 2 is your landman will need to prepare a mineral ownership report on your property. Now, the property, the mineral ownership report, this is exactly what it sounds like. Who owns the minerals? Are there active leases on the property? Has surface been waived on the property? This is an important first step because what you'll need to understand is, how many mineral owners are there. If you own 100% of your minerals, then you don't need Rule 76 order approved. What you'll need to do is file a surface waiver, and then you're done, right? But if you don't own 100% of minerals, or maybe you own 0% of the minerals, then this Rule 76 application is very valuable for you. So after that, step 3 is your engineer or architect will need to prepare a land plan for your property. This land plan is pretty basic. It's just showing the border of your property, the location of drill sites and access easements in the property, and then maybe a subdivision in the property. Now, subdivision is a very informal term. This doesn't need to be a plat. This doesn't need to be something very particular. It just needs to be a group of like a couple of acres that have literally been subdivided. There's lines dividing the property. That's the definition of a subdivision in this context. So the next step is step 4, which is the oil and gas consultant will approve the land plan. So a big step of this is preparing the land plan, understanding what the land plan needs to look like, and then submitting it to your oil and gas consultant and lawyer and getting them on board with this process. These oil and gas consultants and lawyers have a reputation and a track record that they want to protect. And as part of protecting that, they want to make sure that they have approval of the land plan and think that they're actually going to be successful in this process. They'll also provide additional comments if they don't think something will fly with the Railroad Commission. So then the next step after the oil and gas consultant and lawyer approve the land plan is the land plan will be submitted to the county. In my experience as a county commissioner, the county commissioner will put this on their agenda. They will provide their approval. And by approval, it'll more likely be some sort of note that says that they don't object, or that they have no comment. That is your de facto approval. And once the minutes of that agenda are released, you'll need to save those and keep those in your file because they'll be relevant later. So once the county has provided approval, the surveyor will survey the property, the drill sites, and the access/pipeline easement within the property, to get more exact legal descriptions, and then also have little mini surveys for these components. And these will be necessary for the next step, which is step 7, is the engineer will need to prepare an exhibit for the Rule 76 application. Now, the engineer, meaning surveyor, has already surveyed the property, so just plugging in these surveys into one singular exhibit will be the task. I'm going to provide material for what exactly this exhibit needs to look like. It's pretty bare bones. It's not difficult. It's just very specific. So the next step is step 8, which is submitting materials to the oil and gas consultant and lawyer. So now that you have your minutes from the land plan being approved, you have your surveyor having prepared his surveys of the property drill sites, easements. You'll need to submit all of these materials to the oil and gas consultant and lawyer so that they can prepare the Rule 76 application. Now, it's been my experience, they usually go off and they spend about a month preparing this Rule 76 application, maybe asking you questions along the way. But it'll take about a month for them to prepare that. Step 9 is the Rule 76 lawyer will submit the Rule 76 application to the Railroad Commission of Texas. And the Railroad Commission will acknowledge receipt and also begin to set a date for your hearing. That hearing will occur, it's usually about 3 months later. So the reason for that's in the next step, but it'll be a little bit lengthy process until they set the hearing, but you get a say in what date you set the hearing. Step 10 is the landman will notice the affected mineral owners of the Rule 76 hearing. Now that you're going to permanently change the way mineral owners are accessing the property, because you're doing that, you'll need to notice the mineral owners, and they have an opportunity to come to the Rule 76 hearing. We can talk about that later in other videos, but they are noticed about the hearing. Step 11 is the Rule 76 hearing with the Railroad Commission of Texas is held. Now, before that hearing is held, usually the oil and gas consultant and the oil and gas lawyer will want to sit down and talk about, okay, here's some questions I'm going to ask you. Here's how this hearing is going to go. You'll do a dry run at least once to get comfortable with the process, and then it's usually the next day you end up actually having the hearing itself. Now, at the end of that hearing, the Rule 76 hearing, the Railroad Commission will indicate, hey, we do approve, or hey, we're not going to approve. They'll give you an indication of whether they're going to approve the order now and issue the order. So the Railroad Commission will, a couple weeks later, if they approve, they'll issue their order. And then a couple weeks after that, literally 2-week increments, a couple weeks after that, they'll mail an original copy of that Rule 76 order to the Rule 76 lawyer. And they will then, it's been my experience that the Rule 76 lawyer will prepare a memorandum. And then they'll give you the original copy of the Rule 76 order, and you'll stick that behind the memorandum. And then the last step in this process is filing that memorandum of record in the county in which you've submitted the Rule 76 application, where the property lies. And then you're done. Once you have that recorded memorandum, then you're pretty much done with this process. Now, it is important to remember that within 3 years, you're going to need to have either commenced construction on roads or utilities within the property that you made the Rule 76 application for, or you'll need to have sold a lot within that property to a third party. If you don't accomplish the either this construction requirement or selling a lot to a third party within 3 years after the Rule 76 order is approved, then that Rule 76 order is essentially invalidated. So you need to vest your rights through doing construction or selling that lot. In my subsequent videos, I'm going to describe each step in more detail, provide additional exhibits. Again, all of this is free. I'm not selling exhibits or materials. I just want to give these to you so that you understand the process better and can perhaps use them to help speed up the process, make it a little less costly, and just generally help you out. That's my Rule 76 explanation for today. I will be talking with you guys soon.